Hi again, and welcome back. Attorney Steve Vondran. We are talking in this video about DMCA law and what you need to know. Okay, DMCA, what does that stand for? Digital Millennium Copyright Act. Let's get going. Here we go. Okay, what is the DMCA? The DMCA was signed into law in 1998, and there's essentially 5 titles. The title that's most important and most relevant is Title II. Title II is known as Axilla. Online Copyright Infringement Liability Limitation. Say that 5 times fast. So that's the law, but let's go through some of the basics now. The basics are the law adds Section 512 to the Copyright Act. So there's a new amended Section 17 U.S.C. 512. It basically does 2 things. 1, it creates liability and safe harbors for online service providers so they do not go out of business due to copyright infringement claims, what we call secondary liability. So in other words, if Google or YouTube was sued for every infringing photo that was ever posted online, they would never be in business. So it provides liability safe harbor protection, okay? Number 2, the other main purpose of the DMCA, this section, is to prohibit devices and services whose primary purpose is to avoid access controls. So it's anti-circumvention tools. It's protection for the creators against people that are hacking to get into their products, okay? And what we call that is a Section 1201 claim. Now, an OSP, an online service provider, must meet certain requirements to get the safe harbor liability protection. So we're talking here about Section 17 U.S.C. 512C. If you qualify, you won't be liable for secondary copyright infringement. It's an affirmative defense for an online service provider, which means you raise it and you prove it, you show that you're in compliance and you're good. Then you won't be liable for copyright infringement. So this is really important for these big companies, Facebook, YouTube, Twitter, all these developing companies, all these online stores that allow people to sell arts and crafts and other things, okay? Now, so what it means, however, is you're not liable for monetary relief, which means you can't be sued for money damages. But you can still be subject to some injunction provisions where you would have to be forced to take down the infringing material. Now, if you don't qualify, you can still be held liable if copyright infringement is proven. But if you don't comply with the statute and your online service provider, if they prove copyright infringement, then you've got a problem. If you have the safe harbor defense, you're good. All right, so some of the requirements to make sure that you're getting the protection of the liability safe harbor is 1, you got to register with the U.S. Copyright Office. You have to designate an agent for service of process. That's the first thing. It's easy to do. You can do it online. I have a video out on that if you're wondering how to get this done. You can go out and check that out, okay? Just Google Vondran Register DMC Agent. 2, you need to adopt a policy to deal with repeat infringers. So you're going to have people that are sites like Facebook, Twitter, YouTube, they're coming to the site over and over and over and over and over again. You have to have a policy to deal with repeat infringers. For example, YouTube has a 3 strikes. Any YouTubers out there, you know they have a 3 strikes rule that you're allowed to infringe and get in this problem. You're going to get a strike, a second strike, third strike. They're going to terminate your account access. That's a policy for dealing with repeat infringers. Third, the online service provider must not interfere with reasonable copyright protection measures, such as watermarks, digital rights management technologies, things like that. So they can't prevent copyright owners from trying to do something to monitor their product and go after it. Okay. Also, there must be no knowledge of infringing activity, and that means there's no actual knowledge or no what we call red flag knowledge. You know, something that you should have been aware of, facts and circumstances raising, thoughts that there is infringement going on. So that's what we call red flag knowledge. So those are things. So they must not have any knowledge of the infringement going on. And that's coincidentally why you send the DMCA letter. You send it to YouTube. If they don't take your stuff down, you say, well, I told you, and you left it up there for the last 5 months. So that's, kind of the way some of the claims work. And finally, must expeditiously respond to takedown notices. What does expeditiously mean? That's the stuff that lawyers grapple about. But it means, get it done. So even if you're not perfect as an online service provider, doesn't mean you're not entitled to the protections. There are cases that I've read where even, if you've done it 10,000 times, but you did it wrong 8 times, you may still be protected. So just bear that in mind. 512C, who benefits? Some examples of this. YouTube may contain some videos that contain infringing music or video clips. You send a takedown notice to YouTube, they deal with it. Etsy stores or these other arts and crafts stores where you're allowed to sell arts or crafts, jewelry, those kinds of things that can be sold. A lot of people don't know that jewelry can be subject to copyright. So those kinds of stores, they get takedown notices, they have to process them. Online education courses, that's another one. I had a potential client that was looking at us because what he did was a online education course for money. Somebody had somehow swiped it and put it up on a free site. And so now you have copyright infringement up on a free website. So that's another example. Photo sites, Facebook, Twitter, Instagram, places where photos can be posted, they're going to have a DMCA policy. You can usually find it on the bottom of their website or in a notices section saying, if you have DMC notices, here's my agent. Contact my agent. And another big area is these porn tube sites where they become members of an adult pornography site and they download some videos and they post them up on other free porn sites. And so that gets everyone up in a bunch, and that can lead to a lot of litigation as well. DMCA anti-circumvention is the other part of this law. This is what I call Section 1201. This prohibits devices or services that are primarily designed to circumvent access control technology. For example, password cracking tools. You make a product that helps you crack into the passwords or crack into a website. You may find those tools are illegal, even if they have a legitimate purpose. If they have a limited purpose other than to circumvent, that can be a problem. That can run afoul of the DMCA anti-circumvention laws. Or if you're marketing a product as a circumvention tool, in other words, buy this product and you can get through Adobe's ebooks. Things like that can raise problems, okay? There's civil and criminal penalties. They can be very large penalties. So you need to be careful of that. And that, again, that is to protect copyright holders. DMC takedown, notice and takedown process. How does it work? You see something up on YouTube, you see something on Facebook, Twitter, Instagram, something that's your copyrighted work. You're the aggrieved party. You send a takedown notice to a designated agent. If they have no agent, you would send it to the site owner. You would put them on notice. This puts them on notice that you're seeking to enforce your copyrights. The OSP is going to disable access to the material. And it's optional, but the OSP could have provided for counter notification rights. That's a right to dispute the takedown letter and say, wait a second, this is fair use. I have every right to use this. It's a parody, or I had, what do we call it? I have rights to use it, in other words. I have, anyway, escapes me right now. But at any rate, so you have this situation where a counter notification, Creative Commons is what I'm trying to say. You have Creative Commons rights that they actually gave you the rights to use their copyrighted content. So if a counter notification is filed, usually the OSP will send a notification to the aggrieved party and say, hey, they filed a counter notification. The information, the content's going to go back up in 10 to 14 days unless you file suit in federal court and let us know about it. So that's really what it requires. Then the aggrieved party has to make the decision. Do we want to spend the money? Do we want to go after them? One thing that I put a note here, you might want to consider monetization. This is a good time to get in touch with the other party and say, hey, look, we could fight this out in court, or give me 20%, let me monetize, let me put a banner ad or whatever. So you can strike a deal, you can enter into a licensing agreement, whatever you want to do, okay? So that's the process. The DMC notice requirements. This is key. So if you're going to send the DMCA notice, you want to make sure you're doing it right. You don't want to just, I've seen some really horrible ones. You want to make sure you're doing it right. Okay. First of all, main point needs to be made in good faith. Okay. So this is what I call the 512F bad faith actions. We'll talk about that in a second. But you need to make these in good faith. You need to make it under penalty of perjury. You should consider fair use before sending it. Somebody's using little bits and pieces of your clips for commentary, reporting, and they're just taking little snippets of your clips. I know it may seem kind of weird, but there are fair use rights in the world, and they do exist. So you should consider that. I think there was some recent case law that came out that said if you don't consider fair use, meaning you don't have a documentable way to prove that you actually considered fair use, then you could have a big problem with your case. So always I would go through, document the fair use case, the fair use elements. There's 4 elements, and you can Google Vondran fair use and find out those elements. Not going to talk about them right now. And again, you need to make sure it's a copyright claim and not like a trademark or right of publicity or defamation. Those don't count. The DMCA is the copyright. It deals with copyright. None of these other things qualify. So don't mistakenly send a DMCA trying to get all riled up when you don't actually have a copyrighted issue. You need to provide your contact information, and you need to sign it under penalty of perjury. So you need to have some statement in there. Foregoing is true to the best of my knowledge under laws of penalty of perjury under the laws of the state of blank or under the laws of the United States of America. You need that statement, penalty of perjury, in there. And if your DMCA notice is no good and you go in and you try to file a lawsuit and you're trying to sue YouTube, don't be surprised if they say, Judge, here's what we got. This is not much of a takedown, and we didn't even know what was going on or where the infringing content was. And as I noted here on the one bullet point, you need to identify your copyrighted work, send them a registration if you have one, and the location of the infringing work. That's another very important, that's one of the requirements. So again, give the good thorough notice, make sure you're sending it to the right place, to the designated agent or to the site owner. If they don't have a DMCA agent, they don't know anything about the law, send it to the site owner, put them on knowledge, let them know that you have some rights that you're trying to enforce. Again, similar requirements of the counter notification, good faith, penalty of perjury, signature, same type of thing. All right, what is the bad faith action? Yes, you can bring a lawsuit against somebody if they're filing either the notice or the counter notice in bad faith. There is a cause of action built into the law under the 17 U.S.C. 512 for these bad faith actions. Now, realize knowing misrepresentations are prohibited, but also bad faith mistakes can be the subject of 512F actions. And so again, you really need to think about it, and you don't want to be facing, as I noted here, damages, attorney fees, punitive damages, those kinds of things. So it's ultra important, actually, that perhaps you get a copyright attorney involved and say, here's what I have, here's what I'm going through. I don't want to be liable for a bad faith DMCA takedown notice. Now you're above, heads and shoulders above the crowd, because you understand that there is a bad faith element to this law, and you don't want to be caught in the web, or you don't want to get your foot caught in the trap, right? So you must know what is and what is not copyrightable, okay? And that means some things are not copyrightable, such as ideas, facts, concepts, plots, instructions, scenes of fare, like you're making a video game and you have a scene of the golf course. You can't get a monopoly on the scenes from a golf course. Other people are going to get to make games with scenes of a golf course. So be careful. Don't get pulled into the trap. Parody, parody is really tough. They say parody is like shooting at the king. You better be good, because if you miss it, you end up in copyright court. But parody is another thing. Have you considered it? Think about it. You got to think about it. Transformative uses may be protected as well under copyright law. So if you take snippets of different pieces of copyright work and you mix it into something totally new, that could be covered by as a transformative use and not copyright infringement. So it's helpful to know this so you don't end up stuck in a bad faith action. And fair use, again, is the big one. You know, there's so much nowadays. You'll see content on YouTube creators. It'll say, this is a fair use. They're telling the copyright owner, I may have your video in here. I may have a little piece of your music or something, but it's fair use. I'm commenting, criticizing. That's, like I said, it's a whole nother video, but make sure you are aware of this. And also, finally, did you give Creative Commons rights? You may have put something up on various websites that allow you to set various rights. You may have given somebody Creative Commons rights to use your work, parts of your work commercially, and you may not even know it. So it's good to make sure before you're sending these DMCA letters to make sure you know what you're doing so you don't end up being on the defendant side of life. Does that make sense? All right, this is another unique feature of the law, 17 U.S.C. 512H subpoenas. This section says a copyright owner or a person authorized to act on the owner's behalf may request the clerk, this goes to the clerk of any United States District Court, to issue a subpoena to a service provider for identification of an alleged infringer. So if you think someone's infringing, you can see their screen handle or their name, but you don't know who it is, you can send a 512H subpoena to what we call unmask. Rip the mask off and find out who they are so that you can get on it. How do you do it? There's, again, specific requirements, DMCA notice, the notice that we just talked about. You need to send a letter to the clerk of the court along with a sworn affidavit, okay? So you have specific requirements. But it's nice. You don't have to actually file a complete lawsuit. You can get a subpoena and unmask somebody. And that's it, folks. Any questions? I got one final question for you. Who signed this bill into law? I'll give you 3 seconds. Which president? Nobody? Anyone? Anyone? Anyone?
Bill Clinton!
We have a winner! Yes, Bill Clinton signed this into law in 1998. And that's about all I have, folks. If you need a consultation, here's where to find us, dmcacounsel.com. This is attorneysteve.com. This is general legal information only and not legal advice or a substitute for legal advice. This is an advertisement and communication. Excuse me. And we hope you've enjoyed this video. If you've liked it, give us a thumbs up, give us some comments, give us a share, subscribe, and we'll see you again. Hope you've enjoyed the video. Thanks a lot.